All rise. This court of common pleas in and for the county of Clermont in the state of Ohio is now convened with the Honorable Judge Jury sitting by assignment. Please be seated.
Is everyone ready to proceed?
Yes, Your Honor.
So there were various motions filed, and I'm ready to rule on those motions. But if anybody wants to be heard on those motions before I do, I've read the responses, I've read the replies, and read everything that with respect to the motions I'm going to be ruling on. But if there's something that you want to add to what you presented to me, you can do that now.
Or may I inquire?
Yes.
So we filed late yesterday a motion to quash the subpoena on Mr. Coley. I'm prepared to argue that should be needed.
I added that to my list.
Yes.
Anyone?
Your Honor, on the contempt motion and the protection order, there were, I filed a contempt motion on regards to false information being filed. So if you're going to hear that motion, I do have information on that motion in particular.
Go ahead, say whatever you want to say.
So in the protection order, I'm sorry, the ex parte hearing, Ms. Thomason referenced that Magistrate Mitchell said, do you have a copy of a video related to the respondent and his son? And Ms. Thomason replied, no, I do have the audio. I'd be happy to play the court at the time down here. I can't get it on the screen. I have irrefutable proof that Ms. Thomason lied under oath in her testimony in some exhibits that I would like to present to the court on that contempt motion.
So we will get, what I'm going to do is rule on the motions that you file. That will include the state's motion, because I saw that this morning. And then after that is done, we're going to proceed to the hearing on the civil protection order.
Okay.
Everybody okay with that?
Sure.
Does anybody have anything else you want to add on all the I would say the raft of motions that I received finally? So first is the objection and motion to quash the subpoena issued to Michael Merriman dated June 20th, 2025. When it says issue 2, that was what he requested, I believe. And the court finds that the subpoena issued to Michael Merriman dated June 20th, 2025 fails to provide the necessary information and satisfy all the requirements under Civil Rule 45. Among other things, it fails to give information as to the name and address of the person or entity issuing the subpoena so that timely objections can be made. There are legal requirements with respect to the issuance of subpoenas. I went through those and matched those up against what was filed, and that's my conclusion. The subpoena is being used improperly in that it seeks discovery through the use of a subpoena rather than through normal discovery procedures. The purpose of a subpoena in a civil case should not be to obtain discovery. There are other procedures that are available for obtaining discovery. And those are the ones that we have to use. So the defendant's motion to quash the subpoena is granted. And that again is as to the objection. Motion to quash the subpoena issued to Michael Lehrman dated June 20th, 2025. The second grouping of motions pertain to objections to the contempt motion filed by the defendant William Thomas on June 23rd, 2025. In this regard, my finding is that Ms. Thomason is correct that there are requirements for a finding of contempt. These requirements include a valid order issued by a court, knowledge by the offending party of the issuance of the order, and failure by the offending party to comply with the order. There is no evidence from which the court can make those findings based on the submissions of counsel. So, with respect to that, the motion to quash that, the motion to quash is granted. There was another objection with respect to the same motion that was filed at a later date. The hearing on the motion to quash was rescheduled from June 20th, 2025 to July 3rd, 2025. The argument was made that that doesn't apply to, that it's a new motion that's filed. In fact, it's the same motion being filed under at two different times. And so the rationale for granting the motion to quash remains the same, no matter which date is used. The defendant's motion to quash is granted. Excuse me, I believe it's denied. The motion to quash was found to be well taken. The next one is the objection for motion to quash filed by the defendant Sarah Sowers on June 25th, 2025. The court finds that the subpoena issued to Sarah Sowers dated June 20th, 2025 fails to provide the necessary information and satisfy all the requirements under Civil Rule 45. Among other things, it fails to give information as to the name and address of the person or entity issuing the subpoena so that timely objections can be made. The subpoena is being used improperly and that it seeks discovery through the use of a subpoena rather than through normal discovery procedures. The purpose of a subpoena in a civil case should not be to obtain discovery. There are other vehicles for obtaining discovery, and using a subpoena in order to get discovery is simply not a proper use of the subpoena. And so the motion to quash the subpoena is granted. Then the next one is motion to dismiss defendant Thomas's contempt motion filed against plaintiff Whitney Thomason on June 26, 2025. Just as was set forth with respect to some of the other pleadings, the defendant has failed to satisfy any of the requirements for a finding of contempt. Ms. Thomason accurately indicated what needed to be found. There has to be a valid order issued by a court, knowledge by the offending party of the issuance of that order, and failure by the offending party to comply with that order. If those three things are present, there's contempt of court. If those three things are not present, there is not contempt of court. And so the motion to quash and so that's the ruling on that motion. The motion to quash subpoenas is granted. That gets to Mr. Excuse me, Mike.
Mr. Jacoby.
Please.
Jacoby.
Yeah, Mr. Colby's issue. There's no legitimate purpose for the issuance of subpoenas at this point in the proceeding. In other words, when I went through the docket, the last thing I saw last night, as I was doing my final work, was the issuance of subpoenas, just kind of out of the blue. I can see no purpose to be served by the issuance of the subpoenas. You issue a subpoena when you want someone to be present for a hearing. You want to make sure that they're present, so you issue a subpoena for that. There are no hearings. There's the hearing today, and there's the hearing next week or the week after. I'm not sure which it is. Other than that, the subpoenas were not proper. I will say this generally with respect to some of the motions that were filed. The law in civil cases is very clear. Subpoenas are not to be used to obtain discovery. You don't issue subpoenas and put a list of things on there that you want served on you. There are other vehicles that are available for doing that. Proper discovery by use of discovery tools is the proper way to proceed. A subpoena is not the proper way to proceed. So if you continue to file subpoenas for the subpoenas that were issued most recently, I don't believe are for any hearing date, right? Mr. Gass?
To my knowledge, Judge, they're not.
Right. It's just like out of the blue, these subpoenas are filed, and it's just improper. In civil cases, if you have discovery, there are vehicles using that discovery. I would make this suggestion to both sides that if you have questions or you don't understand things, that you consult with an attorney, a licensed attorney who can give you advice. Proceeding without having any legal knowledge of your own is not your fault, but there also are ways of getting that knowledge by going to an attorney and getting their advice and their suggestions. So issuing subpoenas for no purpose is not proper. I believe those are all the matters that were brought to me. We're obviously going to have the hearing on the motion for civil protection order.
Your Honor, I'm not sure that you addressed the subpoena to Deputy Swallow.
I meant to do that. So there were a bunch of subpoenas issued recently, I think by both sides.
No, sir, I didn't submit one.
Okay, then I apologize for saying that. All those subpoenas are not proper. The subpoenas that were issued to the prosecutor's office, I'm ordering quashing.
Thank you, Judge. Have a good day, Judge.
Thank you, Your Honor.
If there is a hearing or some matter that the party feels that you need to be present, they'll issue a subpoena and we'll cross that bridge at that time. But issuing a subpoena for no reason is just not proper.
Your Honor, we're grateful for your time.
Thanks.
Thank you, sir.
Thank you, Your Honor.
So I believe those are all the things that were before me to rule on preliminarily.
So,
Yes.
were you able to look at my motion to limit media access. I submitted it late yesterday after I was threatened with the media presence.
And your concern, I glanced at it, probably came in kind of late. Go ahead and tell me.
Due to the procedurally defective subpoenas that Bill Thomas supplied Miami Township with, they complied with the defective subpoena, and in that 400-page document of evidence, Miami Township gave my personal mental health records regarding my doctor, my diagnosis, and the type of treatment that I was receiving. Bill has since used that in public posts to further the escalation, claiming that he was going to have Chris Hicks here today to live stream it to document that I was crazy, amongst a few other patterns of just escalating harassing behavior. His associate is here today to assist him in that. So I have a motion to limit media because of that.
Your Honor, I object. The request to Miami Township and what was filled was a public, everything that was submitted back to me was a public record, submitted by Ms. Thomason of her own free will to the police department. Anything submitted to them is a public record. They were just providing information as public record, which will be in one of the exhibits submitted to the court today.
As explained by representatives for Mark DeColve and Detective Jason Swallen, and now you, all of the subpoenas that Bill Thomas had issued were procedurally defective. I have since been in contact with Joseph Braun about the formal complaint that I made about Miami Township providing those records. There are federal and state laws that protect mental health records along with my doctor's name and the treatment that I've been receiving. Even if he were to have a court order to have possession of those records, he or no associate of his should be allowed to disseminate and share those in an effort to further retaliation and harassment.
Your Honor, again, I object. She submitted this information to the police department free will on her own account and a public record. And she's attesting in her protection order that she is suffering from mental distress. So those records pertaining to this case, she has to prove that mental distress. She submitted this information, and anything submitted to the police department is a public record. And it was obtained from the police department. That was public record, not from a mental health or any sort of mental health professional or medical institution. It was directly obtained from the police department, submitted by Ms. Thompson herself on her own free will.
Supplemental police report that mentioned mental health, my doctor's name, or treatment, even if he were to obtain that legally, which he didn't, there's no law that states he is allowed to share it and use it to provoke harassment and incite the public to show up and to record to also further escalate the harassment. I have case law on this attached to the motion as well. 5 different examples of case law where Ohio courts have recognized their authority to impose restrictions on media when necessary to prevent harm. I have over 12 exhibits today proving the harm and the escalation of harm, even after he received mental distress affidavits that were notarized here in the court, and after he received the police report that I was seeking treatment for anxiety. He decided to escalate the harassment, now including associate Chris Hicks Media, to further escalate that, and they have threatened to live stream and broadcast that today, which I believe is what Chris Hicks is doing. He said, and I quote, "He will get my mental health history all on the table, streaming for everyone to see." That was on 7/1, and I have that prepared here in evidence as well. That I have a copy for you, I have a copy for Bill as well.
So there's nothing I can do about that, but again, you have concerns about release of confidential medical information, I would call an attorney.
Right,
And I make sure that the attorney you're satisfied with that attorney.
right. We are
but
seeking an attorney.
That's not something that's before me today, understand? Okay. Are you ready to proceed then on the civil protection order?
Yes, Your Honor.
Okay. Ms. Thomason, you are the petitioner, so you can proceed,
Do I need to step to the podium or may I speak?
please.
Do I need to step to your podium?
You can use the podium or you can talk, but as long as you're loud enough so we can pick it up on the recording system.
Okay, I'm going to just briefly state how I came into contact with Bill. I have a short statement to read that explains menacing by stalking with references to the ORC. I have a copy as well of Attorney General Yost's interpretation of the law of menacing by stalking. I have a copy for both judge and defendant. So, mid to late May, I reported coaches from Milford High School for allegedly taking kids of the varsity wrestling team out to bars and drinking. I reported this first to the school, and the school didn't seem to be reacting how I thought appropriate, so I reported this to Miami Township Police. After reporting this to the police, I became aware that Mr. Thomas had accompanied another member of the school who was a previous coach, and other serious criminal allegations regarding Milford High School. Bill Thomas has an interest in any wrongdoing that public officials or school officials have been involved with. I had a post on Facebook regarding the superintendent's blatant lies to me in emails about the way that he was handling the case. Bill shared that post to his page sometime close to the end of May. That's how I began to become aware of who Bill Thomas was. In the comments, an old associate who I considered maybe a friend at the time responded in the comments to back me up and essentially say he knows me and trusts me and that we need to sit down essentially and talk about all of this because they have information as well regarding Milford High School. So these two men had an interest in meeting with me to get details. I can start over and swear in.
So you go ahead and swear.
Can you raise your right hand? Do you solemnly swear or affirm that the testimony you are about to give before this court is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
I hate to do this, but I'm going to ask you to start from the beginning.
Oh.
Okay.
In mid to late May, I reported alleged criminal activity with Milford High School coaches, wrestling coaches. At the time, this was the second criminal offense that Milford High School boys coaches and girls coaches were facing criminal allegations. Bill had accompanied a whistleblower who was fired for reporting the first set of accusations to the police. Bill Thomas accompanied this man to file a police report. So Bill Thomas had an interest from the very beginning in the wrongdoings of Milford High School. I had posted on a public page, essentially stating my distaste for the way that Milford High School was handling things. And then I had went to the police to confirm whether or not those allegations were submitted to them for investigation. Bill Thomas has shared that information to his public page on or around May 24th, May 25th, I believe. After he shared that, an associate who
When you say share the information, what information?
I was, it was a Facebook post. I was speaking about the derelict that I thought was happening with the superintendent. The superintendent had sent me a string of emails alluding to the fact that he had done thorough investigation of this criminal allegation.
Your Honor, I'm going to object. This is a lot of hearsay testimony. The filer petitioner has proof of these things. If you need to submit them to the court so I can review them, but at this time, this is hearsay testimony. I mean, I don't have any proof of what she's saying in front of me. We don't even have
That's how I
accurate
came to
names.
know Bill Thomas. It has nothing to do with his character.
To be admitted for that purpose. I didn't ask you, you have the right to refuse to have Mr. Hicks film. I'm not suggesting that you either way.
I did object to that before we went on record. I would like to object to that again.
So I assume you're not filming.
I object to live streaming. I object to broadcasting of this or sharing any of my personal mental health information for personal gain.
So I assume you're not live streaming.
I am live streaming, and Your Honor, witnesses can't, somebody who brings the action can't object to being
Yes,
recorded.
they can. Turn it off now or take it out of the courtroom.
I can take the video off her. So she will be an exclusion zone where it will not record her.
You gave them instructions, correct? Did you give them instructions?
I mentioned that, I did mention to Mr. Hicks that, that he could still audio record, but if there was a request of a victim or a witness, that they wouldn't, if they didn't want to be recorded, then they didn't have to.
What I'm speaking on isn't
That's
activism.
the law.
But she's not testifying as a witness now. She's bringing the action.
She is testifying as a witness. A party can be a witness.
Okay, so I
Turn it
have it.
off or take it out of the courtroom.
I'm sorry.
Turn it off or take it out of the courtroom.
So I can't record any video because of her.
That is correct. You can't have any video of her right now.
So this stops all video. But I believe you're in error. I believe the individual witness could protest, but not somebody who brings the action. The Supreme Court just ruled on that witnesses
She is a
don't
witness.
have a universal right to not be recorded. She's the bringer of the action.
She is a witness. She's testifying.
Then she should take the witness stand.
Would you ask Mr. Hicks to leave, please?
Mr. Hicks, would you please leave the courtroom?
So I can't personally sit in here either.
You're too disruptive, Mr. Hicks.
What did I
Leave the
do?
courtroom.
I didn't do anything. I responded to you.
Leave the courtroom. You were given instructions by the bailiff.
No, I was not given any instructions by the bailiff. That's false.
For your information, there is a recording made of this by the court.